Hello and welcome to the next of our webinars for charities. And today we're going to be talking to you about charity property specifically and giving you an explanation of the regime for disposals of property post the implementation of the Charities Act 2022. So I'm joined today by my colleague, Hannah Harbottle. I'm a legal director specialising in advising charities on all their property requirements, and Hannah is a senior associate who similarly advises charities on all of their requirements for land and property. So what we're covering today. And before I start, I need to give you a couple of housekeeping points. So just to say, this webinar is going to be about 20 minutes of speaking with a bit of time after that for questions. The webinar will be recorded and you will receive a copy of the recording along with a copy of the slides, which does have some useful links in it, so look out for that. If you do have any questions for us, please pop them in the questions box and we will pick up some of those if we have time at the end. Otherwise, if you want to email us with any questions you have, then of course, please feel free afterwards. And finally, you will have a feedback form at the end of the webinar. So please fill that in and give us any feedback. In particular, if there are any topics you would like to see for future webinars, that's really helpful for us to tailor these to what you'd like to see. So what we're covering today, first of all, just a bit of general principles on which apply to anything charities do, in particular disposals of property, and a little bit of background and context to the Charities Act and why there is this regime for disposals, in particular of charity land. Then we'll move on to the rules around dealing with connected parties. We'll give you an overview of the normal position for freehold sales, the rules that apply to disposals which are long leases, that's over 7 years, and then short leases which are under 7 years. Then we'll talk through exemptions from that general position. We'll give you a bit of an explanation about designated advisors reports, which are a new provision which has come in with the 2022 Act. Finally, just a brief explanation of the rules for mortgages, which are a particular type of disposal. And then finally, we will pick up a couple of questions if we have time. So some general principles and things to bear in mind when looking at any disposal of land or property owned by a charity. And I've made 3 points here. So governing document and powers. One of the first things we always look at when advising charities is the governing document of the charity. And this can take many different forms depending on the type of charity. So for a company, it might be memorandum and articles, or for an unincorporated charity, it might be a trust deed, and various other forms. So trustees can only act in accordance with the powers they have under their governing document. So we'd be looking at that, also looking at whether there are any particular restrictions in that governing document, such as restrictions on disposals of property. That leads me on to the second general principle, which is thinking about whether any special trusts apply in relation to the property. And here we're looking at two sort of general different types of land. Permanent endowment, that is, it can be things other than land, but in the context of property and land, that is often property which may have been donated to a charity. It can often be land or property that's been owned for a long time. And there we're looking at broadly two different types of permanent endowment. So we may have investment permanent endowment, which is land or property which has been donated to the charity specifically to produce an income, and the charity may well be restricted in actually disposing of that because the original intention was for it to sit there and produce this income. The second broad type of permanent endowment in the context of property is functional permanent endowment. So that may be property which is part of the original endowment of the charity. It may have been donated specifically for the operation of that charity. So here we may be looking at schools, almshouses, recreation land, that sort of thing. And again, there will, because of the very nature of that property, it will necessarily be restricted in being disposed of. And in that case, we may be looking at needing charity commission orders. The other type of land, which we're looking at there with special trusts, is designated land. And that is land which is held by the charity for particular purposes of the charity. So it's similar-ish to permanent endowment and can often be confused, but it's very slightly different. So this is land, again, it could be school land, playing fields. It's land that must be used for that particular charity's purposes. That kind of land perhaps can be disposed of, but there will be a requirement for it to be replaced because otherwise perhaps the charity wouldn't then be able to function. So for a recreation ground charity, it needs to have that land and able to function, but perhaps it doesn't need to be on that particular site. So possibly that site could be sold if it's being replaced with another suitable site. So that's another key thing to look at. And then my third point is very general principles of trustee duties and good decision making. And there's a really excellent Charity Commission leaflet on that. So do go and have a look at that for some further information. But just to give you an idea of the general principles we're looking at there. So governing document, as we said, need to act in accordance with the governing document at all times. Trustees must always act in the best interests of their charity, of course. Charity trustees should ensure that they're well informed and that they have all the relevant information that they need to have before they make a decision, in particular a fundamental strategic decision like selling some land. When trustees are making decisions, they should look at all the relevant factors and they should ignore any factors which are irrelevant to that decision, and they should manage any conflicts of interest which exist properly. Generally, the obligation is for trustees to reach a reasonable decision. Now, that doesn't mean that the Charity Commission is looking to you to make the right decision. It may not be as simple as that. The idea is that trustees should come to a reasonable decision, which a reasonable board of trustees would come to. And so we always recommend that good written records are kept of good decision making. Then moving on briefly to a little bit about the background to the Charities Act 2011. And don't worry, I'm not going to talk too much about all these different acts. I wasn't actually practicing law in 1855, 1960 or 1992. But I do think it's quite useful to just understand why there are these restrictions, the context for that, and why there is this special status for charity land and why it applies to disposals as opposed to acquisitions, which perhaps are strategically more of a risk sometimes for charities. So this comes from really the special place of land historically as a significant asset for charities. Back in 1855, when the first Charities Act came into force, endowment land actually had to be registered with Parliament, and the consent of Parliament was needed to make a disposal. There was a distinction for certain charities where their land was not endowment land, it was land that had been bought with voluntary contributions. But that regime was a little bit difficult to interpret. But that was the position for about a century, until 1960. This defined permanent endowment for the first time and made that distinction between those different types of land. At that point, consent was still needed from the court or the Charity Commission to make a disposal of land which was part of a charity's endowment. But if land had been bought from expendable funds, consent wasn't required. The 1992 Act really brought us to the position we're in now, and it introduced this sort of concept of a procedure for sales of land, so that charity trustees could be more free to make disposals and to go through a process which would show good decision making, but without having to jump through these hoops of always having to go to the Charity Commission. The 2011 Act clarified things further, and as of March this year, most of the provisions of the Charities Act 2022 have come into force. Now, those amend the regime in the 2011 Act. There are a couple of points outstanding. The most important point for all of you will be that the position for certain universities and colleges, so that's Cambridge colleges, Oxford colleges, Durham, also Eton College and Winchester, there will be changes so that they are actually regulated by the Charities Act in terms of the disposals they make, but that's not coming in until 2025. So I'm now going to hand over to Hannah, who's going to talk you through the current regime post the 2022 changes.
Thanks, Louisa. Afternoon, everybody. So yes, I'm going to hopefully, apologies, not go through too much of the legislation. It's not the most exciting to rattle it off to you, but I just wanted to touch briefly on the general prohibition. I think most of you will be aware, but for those that aren't, there is in the Charities Act a general prohibition on disposing of charity property without an order from the court or the commission. Disposal, you've got to be careful because disposal is very widely drawn. So it's things you would expect like a sale, grant of a lease, but it also captures things like the grant of easements, away leave, and it can also catch a surrender of a lease. So if you think of a charity giving up a lease before expiry, that surrender counts as a disposal, so you may well need to go through the regime of getting consent. There is, however, an exemption process that you can follow so that you don't need to get an order from the court or the commission, which I'm just going to run through briefly. But the other point that you need to think about as well is who you are transacting with. It's very important to identify whether you have a connected party, and the Act has quite a detailed definition of who counts as a connected party. It's on the screen there. I'm not going to run through it all in detail, but as you can see, it's quite wide, and it catches anybody connected with the charity. That's not just trustees and donors, but it can be relatives of them, persons working for them, institutions controlled by any of those people. So you need to be really careful to identify the other party that you're transacting with and make sure that they're not a connected party, because if they are, you may need an order from the court or the commission, even if you could otherwise rely on what we call the whitewash procedure, which is a set of processes to go through where you wouldn't need an order. So it's really important to identify early on whether you've got a connected party involved and whether you are then going to need consent. So just to touch a little bit then on the, as I say, the whitewash procedure, which means if you can follow these processes, then that means you are saved from the time expense of going off to get an order. So it's set up in different categories depending on what your transaction is going to be. So dispositions other than short leases is covered by section 119. So this would be sales, long leases over 7 years. It specifies that you need to obtain advice from a designated advisor. It used to be qualified surveyor, but now with the new regime, they refer to a designated advisor. And I'll come on a little bit to what that actually means and what they need to do. You need to obtain a report from them, which will set out the terms of the proposed transaction. Say it's a sale, and the advisor will comment on the appropriate price, whether you've done everything you can to maximise value for that proposed sale, and they'll make recommendations for advertising if they think is appropriate. So that's the process you need to follow for anything other than short leases. So sales, long leases. If you're doing a short lease, it's a slightly different process. It's a lesser bar to have to achieve. You still need to obtain advice, but it doesn't necessarily need to be from a designated advisor. So it can be a person reasonably believed by the trustees to have requisite ability and experience. So you'd need to form a reasoned view as to whether you think the person you're taking advice from is appropriate to give you that advice in the circumstances, and then make the decision that the terms of that proposed lease, for example, is the best that can reasonably be obtained. And as Louisa's touched on briefly already, there are additional restrictions if you're trying to dispose of designated land. So you need to be really careful, always go back and check how the land is held and whether it is designated land to see whether you have a higher level that you need to meet, because that will require in a lot of circumstances you need to take some extra steps, for example giving a public notice. So it's important to make sure you've identified the land that you're dealing with to make sure you're meeting those extra requirements if they apply. So moving on then briefly, I just want to talk about a couple of exemptions. There are some further exemptions. I haven't listed them all here because there's a lot of them. We could do a whole webinar on those. The charity to charity transfer exemption. This specifies that you can make, a charity can make a disposal to another charity for less than best price, less than the open market price, for example, that you would sell on the open market, if it's in furtherance of the selling charity's purposes. You wouldn't need to go through the reporting process, obtaining the report, if you could show that it was in furtherance of the charity's purposes. This happens quite often on incorporations or mergers. So if a charity is incorporating and it needs to move its assets across to that new incorporated entity in order to finish its incorporation, that happens quite often in that circumstance. The lease to a beneficiary at less than full rent is another exemption, which if the property is being used for the purposes of the charity that's making the disposal, the lease, then there is an exemption there that you can rely on as well. But it's important to think about all of the circumstances. As I say, these aren't all of the exemptions, so it's really important that you take appropriate advice to make sure that you're not relying on an exemption you think applies. Okay, so as I mentioned, I'm just going to talk a little bit about designated advisors. There are specific regulations. If you have to deal with this regularly, I would recommend you familiarise yourself with those. When we send out the slides, it's got links in there to the regulations, but you can look it up. So a designated advisor is the person that will need to give you a report if you want to rely on the whitewash procedure, the exemption under the Act, to avoid having to have an order. So it can be, I've highlighted there in purple the change that's just come in. So it used to be a fellow or professional associate of RICS, and it's now that person or somebody from the National Association of Estate Agents or the Central Association of Agricultural Valuers. And it's also really important to make sure that the trustees appoint somebody appropriate, so somebody who they believe has the ability and experience to give a value of the particular land that you're dealing with and the transaction you're proposing to do. So if it's a residential sale, for example, think about who's experienced in that. If you're doing a complex strategic land matter, think about getting advice from somebody who regularly deals with strategic land matters. The Act has also clarified that you can take advice in appropriate circumstances from a charity trustee, an officer or an employee. But again, it's really important for you to think about whether it's in the charity's best interest and whether it's appropriate for that person to be giving you advice. You need to think about whether they're insured to give you that advice, whether they have the necessary skills and qualifications. So although it can be a way of saving cost if it's appropriate in the circumstances not to have a full designated advisor's report, but you also need to think about whether by doing that you are getting the best advice possible for the charity. So just something to think about there. And then I'll just touch briefly on what the report needs to contain. Again, look through the regulations. It's got everything set out there, but these are just a couple of bullet points. So you need to specify the value of the land. That's a fairly obvious one that you'd think of, especially if you're making a sale or a lease. You need to know that you're getting appropriate rent or purchase price for it. And any steps that could be taken to enhance that value is also a really interesting one to think about. Whether there might be more value splitting the site up, selling it off in different sizes, whether and how it should be marketed. It used to be compulsory for marketing, but it's now as recommended by your advisor. So if they say, actually, this is a great deal, you're not going to get a better one anywhere else. And that, they'll give you proper advice. Again, if it comes back to if you've chosen an advisor who is appropriately experienced, an experienced strategic land agent, for example, they will be able to give you advice about when and where the property should be marketed and on what terms. And they'll comment, as it says here, anything else which could be done to ensure that the best terms are reasonably being obtained, and any other matters that they think should be drawn to the trustees' attention. So if you are instructing one of these reports, it's really important to make sure that you get advice on all of those points, get what you're paying for. But the report also needs to specify that the advisor has appropriate experience dealing with transactions of that nature, dealing with the land, and also specifying that they have no conflicts, that they're acting for the charity in their best interest, and that they're not conflicted in any way. And that's a really important point that we often come across. So, as I say, have a look at the regulations, make yourself familiar with them, and then you know that you're getting a suitable report that you can rely on. So Louisa is just going to touch briefly on mortgages, which is another type of disposal that you need to think carefully about. Louisa, back to you.
Thanks, Hannah. So yeah, just going to talk about this very briefly. Let's go back to the right slide. There we are. So mortgages are a type of disposal, but they have their own separate sort of section in the Act. The requirements are slightly different from a freehold or leasehold disposal, and broadly fall into two categories. So mortgages to secure a loan or grant. So that's your classic mortgage for the secured on the land. What's needed there is really financial or accountancy advice. So this isn't legal advice, but this is advice on, whether the terms of the particular loan are affordable, whether they're the right thing for the charity to do, whether they can make the repayments. As we've said, this advice, it's been clarified that this advice can now be given by somebody in the charity. Again, consider whether that's appropriate, and that will really depend on the circumstances and the nature of the loan for your charity. The other one, which we see less frequently, is a mortgage to secure any other proposed obligation. And an example of that that we've dealt with recently is where a charity client has it's securing funds due under a court action, and the idea is to secure that against the land. That's what the person who's owed the money wants to do. And so in that case, the requirement is for the trustees to look at, is it reasonable to do that, having regard to the nature of the obligation? So how much are we talking about? Is it reasonable to secure against your land a debt of, £100, or is there a different way of doing it? And actually, in that case, we did manage to convince the other side there was a different way of doing it, because it seemed disproportionate to have a mortgage on our land which would tie up disposals and be sitting on our title register. Moving on from mortgages to our key points about what has changed. So the main things to highlight, firstly, for the advice requirement, we now have a wider pool of advisors who can give those Charities Act reports. So whereas previously you had to have a report from a qualified surveyor, as Hannah's explained, we've now got 3 different types of advisors, still surveyors. So that's probably most appropriate where you've got sort of strategic land. We have estate agents, so that's a very useful way of selling residential properties, because really an estate agent is best placed to give that market advice in the residential market. And also agricultural valuers. So that's useful where charities have agricultural rural land. Along with that, it has been clarified that as well as going externally, as Hannah's already said, that advice and that report can be given by somebody in the charity. That has probably always been the case, but this has now been spelt out in black and white and is actually built into the Charities Act. We do have reservations about whether people will want to do that, but it can be useful sometimes to save on costs. Also, the requirements for what needs to be in those reports has been considerably simplified and brought down to 5 key advice points. The consultation that was going on was really trying to strike the right balance between charities getting the right advice they need so they don't make unwise decisions, but also recognising that there are so many different types of property and land and different types of disposals. And overall, I think this is striking the right balance. Number 2, advertising. So previously there was a requirement in black and white in the Act that trustees would have to follow the advice from their surveyor on advertising a property, rather than just doing an off-market deal. Now the position is slightly different, so that has been struck out of the Act. And the requirement is for the trustees to consider that designated advisor's report. And in there, the advisor is going to talk about whether or not the land or the property should be marketed. Obviously, if the trustees don't follow that advice, they're going to have to be able to justify that. But it does then allow for a bit more flexibility of where the people don't want to advertise, don't think it's necessary, perhaps there's an obvious purchaser, so it does allow a little bit less of a prescriptive approach there and can help with speeding things up. Next one is that we have an exemption specifically for employees who are occupying the charity's property. So this is specifically for tenancies where they are occupying this as their home. and it is limited to tenancies of a year. So this is really useful for employees who need to live on site, such as private schools where teachers are living there. Previously, this would have been a connected party transaction because an employee is a connected party, and you would have had to have gone to the commission, which obviously is very burdensome. So this is really quite useful exemption. Number 4, clarification about what happens where the charity is a co-owner, which is unusual, but we do see that sometimes, for example, in legacy cases where land is left to a charity where they're jointly owning with another party. So we have in black and white in the Act that Charities Act restrictions do not apply in that case. The idea being that they should only apply where the charity holds the land itself and is making that decision in respect of its own land. The position would be different if, say, the charity had a 50% share in a piece of land and they were looking at selling their 50% share, because that would be a disposal that they were making of their whole interest. It can be quite a complicated issue, but it's useful to have that clarification in place now. And finally, this is more a point for the lawyers really, but the certifications that go in the sales documentation have thankfully been very much simplified. So previously we had one thing that went in the contract, something very slightly in the transfer deed, and it was all, you know, quite fiddly. We now have just a statement about the fact, essentially, it's charity land, restrictions apply, and that the trustees have complied. So that makes things a lot simpler. It also means that whereas previously with some unincorporated charities, you'd need to have lots of different signatures to deal with both the actual execution of the transfer and also the giving of certificates by trustees. It's all now wrapped up in one clause. So that simplification was very much welcome. And now I think we have got a very small amount of time for a few questions. So we can move on to the next slide. There we go.
Yeah, we've had, thanks for those of you who've sent in questions beforehand whilst registering. We're not going to have time, we've run over slightly to answer everything that's come in, but do send us an email separately if there's something you want to pick up with us. But I did want to touch on one question that we regularly get asked, and that's coming back to the point about designated advisors reports, and that's whether the selling agent, now that we've got the sort of wider pool of who can give those reports, whether the selling agent can give that report on behalf of the charity. I know you come across this quite often, Louisa, and our response is usually the same and similar to what I've already said, which is that you need to think carefully about, you know, one of the things they need to specify is that the advisor is not conflicted. So the charity needs to be really careful to think about whether the agent, who is naturally incentivized to get a deal through because they're getting a commission, is the appropriate person for giving that report.
So it may be that if it's a large firm, there might be somebody else in the firm of surveyors or estate agents who can give that report, and it might be the right thing because it might be more proportionate, a bit more cost effective for someone just to help with that. It really depends on the nature of the deal and how strategic, you know, this disposal is. Is there likely to be future scrutiny? If there is, I would rather have somebody completely separate to give that unbiased and independent view. But I mean, overall, I think the direction of travel of this legislation is right, that it's giving that flexibility so that you can choose the right advisor for the right transaction and keep those costs proportionate. Would you agree with that, Hannah?
Yeah, I think so. You know, as with any decision always made by the trustees on behalf of the charity, you need to show that you formed a reasoned view, and that you know you did what was reasoned and proportionate at the time. So if the person you've chosen is appropriate for that advice, then that's fine. But yeah, I always tend to err on the side of caution and recommend somebody independent. So. Perfect. Okay. Well, I think that's us done. So as I say, please do drop us a line if you've got any questions, anything particularly you want us to touch on, and ideas for webinars you want us to do in future. There will be a feedback form, so please do fill that in, and we'll see you next time. Thanks very much.
Thanks.